All right, so just for those who don't know me, my name's Todd. I'm a sessional lecturer here at the uni, and I'm also a research assistant these days. But more importantly, I'm a PhD student at the moment, and my research focuses on the theories of sovereignty. So that's the lens that my book chapter is taking. So as the title says, the CBD terms sovereign rights sovereign right and sovereign rights does not necessarily mean you have sovereignty. So I'm going to explain this. Alrighty, so the aim was to understand exactly what those terms or these terms mean for both the CBD and the Nagoya Protocol more broadly. I did this by engaging with the sovereign theories of Hans Kelsen and Schmitt, as you can see on the slide in front of us. I'll start by just outlining their theories of sovereignty so we can all understand, and then I'll apply this to both the CBD and Nagoya Protocol, just to show that the terms sovereign right and sovereign rights are both legal constructs trying to capture the idea of sovereignty, but it does not necessarily mean one has sovereignty per se. Okay, so Kelsen and Schmitt's sovereignty. So starting with Kelsen, well, the difference between the two is Kelsen sort of argued that sovereignty was this legal concept, whereas Schmitt talked about sovereignty as being a political concept about power. So Kelsen defines sovereignty to be the presupposition of a normative order as the highest order whose validity is not derivable from any other order. So in other words, the highest legal order. Kelsen's description of the law began with this idea of the basic norm, or the Grundnorm, as he calls it. There is no sovereign per se in his theory, but the basic norm is the closest thing to being sovereign. So a concrete example of this is a constitution. Under such, the rule of law is supreme. No one is above the law, and all laws are derived from the constitution. The basic norm is presupposed because it cannot be created by an authority whose competence would have to rest on a higher norm. The basic norm is the reason for the validity of the legal order. And because it is presupposed, its validity, or the basic norm, cannot be questioned. So under Kelsen's conception, nothing is above the basic norm, and therefore the rule of law is sacrosanct and it ought to be followed. So from this standpoint, the state's legal order is supreme. The state gives validity to international laws that they're willing to accept into law. Okay. Conversely, if international law is the supreme legal order, then it authorizes states' legal orders. And so Kelsen talks about the basic norm of international law, which validates states. He also talks about that this being the customs of states. So these norms created by states are binding and ought to be followed. So one way this is formalized is through treaties. In this scenario, sovereignty of the state means that they are subject to international law. Subsequently, international law is therefore the sovereign legal order, whereby it limits the state's legal order. Essentially, international law can limit a state's sovereignty in such a scenario. So this is sort of a basic understanding of Kelsen's conception of sovereignty. Simply put, it's about the highest legal order, either a state's legal order or international law. Schmitt's conception of sovereignty, as I was saying, is about power. It's a political concept. He defined sovereignty to be the sovereign is the person who decides the exception. Now, it's exactly this that shows the limits of law, and as well as Kelsen's conception of what sovereignty is. So Schmitt explained that the exception was some unforeseen extreme danger that could threaten the very existence of the state itself. The problem with the exception being unforeseeable for constitutions is that the exception cannot be codified. Rather, the exception requires a sovereign to have unlimited power. This results in the sovereign having the ability to suspend the legal order in order to do whatever needs to be done to resolve whatever issue that the state is facing. So Schmitt talks about for a legal order to exist, a normal situation is required. It is the sovereign who decides if the situation is normal or not. So the relevance of Schmitt's conception is that it shows the limits of Kelsen's theory and the rule of law. So the clearest example is a state's constitution being unable to respond in a time of crisis. So the best the Constitution can do in such a time is tell who can act. So constitutions, they try their best to nullify the sovereign. They do this by dividing decision-making power. So we see this with governments, with the legislature, executive, and the judiciary. Essentially, this is done in order to protect the state from having the power held in the hands of few or one. So the effect of this is that it hides the sovereign, but what the exception does, however, it reveals the sovereign. So the sovereign is, again, this person who has the power to decide. So Schmitt argued that the legal idea, it cannot translate itself independently, and this is evident from the fact that it says nothing about who should apply it. Therefore, the transformation of law requires an authority. So the authority is the sovereign. The sovereign decides. So he talks about if the state does not have the power to decide, then it's simply not sovereign. Schmitt believed that it was this power to decide is what exactly makes a state sovereign. All right, so looking at sovereign rights, which are covered under both the CBD and Nagoya Protocol. So this is in a Kelsen sense. So in other words, they're both legal terms under legal frameworks operating under international law. So simply put, these do not take into consideration necessarily Schmitt's conception of sovereignty, that being having the power to decide. So under Article 3 of the CBD, it states that states are legally guaranteed sovereign rights to exploit their resources. Article 15 defines the rights and obligations regarding access to genetic resources and fair equitable sharing of benefits derived from their use. It also stipulates that these states have the sovereign rights over their natural resources. They essentially have the authority to decide over their genetic resources. So it also talks about this is to be done by creating conditions to facilitate access to genetic resources that does not impose restrictions that run counter to the CBD. So it's not entirely clear how this is meant to be done, other than states are ought to do this. However, imposing such an ought upon states seems to be contradictory, prima facie, to both conceptions of sovereignty by Kelsen and Schmitt, as well as just the core tenets of the CBD, that being that states have the power to decide subject to making it exploitable. So the genetic resources in question are either those of country of origin or have been acquired appropriately through the CBD. So the problem with sovereign rights, we see this with the term when it comes to country of origin. This is when it comes down to actually having the power to decide. So a good example of this could be the COVID-19. So the country of origin for SARS-CoV-2, it's still, obviously it's not clear and it's still quite controversial, but it appears it might have been in China. So if this is the case and China is the country of origin, then China potentially, well, has the legal sovereign rights to SARS-CoV-2 recognized by the CBD. So if this is the case, well, once SARS-CoV-2 had left China's jurisdiction, the issue becomes about enforcement and more specifically enforcing this sovereign right that they now have. So the legal conception of sovereignty as a right comes apart as soon as someone else has this power to decide. So essentially, once SARS-CoV-2 started appearing in other states, territories, and in areas beyond China's national jurisdiction, it can be said that China no longer had complete control over the virus. Therefore, in a Schmittian sense, in these spaces beyond China, they no longer had the power to decide over SARS-CoV-2. So what this example highlights of sovereign rights and shows why it's important to actually have the power to decide over biodiversity and genetic resources. So as Schmitt's theory explains, having the actual power to decide over such means that you have sovereignty. So a sovereign right is no longer sovereign, I guess, in the sense that if another state has the power to decide. Okay, so the same argument can be put forward again for say, Article 6 of the Nagoya Protocol. So this, again, recognizes sovereign rights in the Kelsen sense. So having a sovereign right, again, does not necessarily guarantee you this state sovereignty. So the clearest example, again, being a virus. So under the Nagoya Protocol, this notion can be extended to, say, traditional knowledge. So if someone outside or beyond a state's power or jurisdiction possesses its indigenous or local community's traditional knowledge, so having a legal sovereign right to the traditional knowledge again appears to apparently or maybe break down. This is because the person who actually has the power to decide over such, possess it, utilize it, etc., is either beyond the scope or outside the power of the state with the sovereign right. So therefore, this state with the sovereign right does not have the power to decide, as Schmitt tells us. If you do not have the power to decide, then having a sovereign right having a sovereign right is not exactly having sovereignty. So this is sort of how Schmitt's theory illustrates the limits of not only just Kelsen's theory, but the rule of law itself. And in this example, a sovereign right. So yeah, that's essentially my chapter in a nutshell. So yeah, thank you.
Wonderful, Todd. Thank you. That's really, it was a great overview of your paper. I'll throw to Michelle. She's got a question.
Yeah, I just wanted to say this chapter blew my mind. And it really solidified some thinking that I had on the PIP framework a couple of years ago. And so I was really happy to see that you use the example of viruses, the SARS-CoV-2 virus, because it really is so hard to pin down who owns something like that, or who has sovereign rights over something like that. Yeah, so I just wanted to say thank you, really, because I just thought this was a brilliant chapter and something totally different that I hadn't seen in the ABS literature before.
Thank you, Michelle.
Thanks, Michelle. Are there any other questions in the group?
Yeah, I've got a quick question. In your chapter, Todd, you talk about the Stockholm Convention. Can you just tell us a little bit about why that's important for the CBD? I didn't know anything about this, and I guess I thought it was really interesting is that here we have an input to the CBD, which we really haven't taken into account when we're thinking about its interpretation.
Yeah, so when I was conducting my research, I was curious where the idea of sovereign rights came from. So I just engaged with some of the commentary surrounding the preparation of the CBD and stuff like that. And I came to learn that, yeah, the exact wording was a copy and paste from the Stockholm Convention from the early 70s. So it was nothing new. It was already established from, I guess, environmentalists in the early 70s. I didn't engage too much further along that path. I was just more curious about the CBD per se. But yeah, I was sort of fascinated by that point that it's just a direct copy and paste from the Stockholm Convention of the early 70s. So yeah.
But do you have any views about why, if there's an old, I mean, this is a concept which has been around since the early 70s in the context of resources. Was there anything else happening around then to posit this? I mean, I guess talking about, I think you hear about the law of the sea kinds of comments and the UN getting into that debate about new international economic orders and those sorts of things.
Yeah, I just know from the early 70s, there was a huge movement internationally and very broadly about just the environment and thinking consciously about the environment. So we saw a number of movements. I know with the law of the sea stuff and more specifically with whales, whaling was a big part of that too. This conscious idea of protecting the environment and knowing that sort of the impacts that humans are having to the environment. So with whales, we saw the discussion, the moratorium coming in, which ended up taking a further 10 years before that actually took place. And obviously there was issues with that moratorium too, because the states that disagreed just left and continued commercial whaling, whereas we saw with Japan, they agreed to the moratorium, but then continued their whaling under the guise of the research whaling. So yeah, it seems like we see in the early 70s, there was just this really massive push to start working towards a better world collectively to do the right things and protect the environment and make sure that the environment has a right or an interest or a stake in future developments. So again, I don't know a great deal, but yeah, that's my current understanding.
Excellent. Thank you, Todd. Daniel.
Hi, Todd. Thanks for that, which I really enjoyed. I think that after World War II, I recall seeing there's some I'm trying to remember what it's called. It's like a UN Declaration on Permanent Sovereignty over Natural Resources. I think it's Graham Dutfield's written a bit about it in the CBD context, but I think he was kind of saying that it came from that post-World War II concern about minerals, of course, like we're obsessed with in this country, like coal and oil and I think particularly petroleum and those sorts of things. So I don't know if there's there's another antecedent of this idea of sovereignty over natural resources. And I don't know if it was a legally binding, I don't know if those UN declarations are always legally binding, but yeah, I'm fairly sure it was Graham Dutfield in one of his earlier books in the 2000s.
Graham Dutfield was that?
Yeah.
All right,
Yeah.
cool. Thank you.